Welcome to From Separation to Settlement, a family law podcast.
Hey there, welcome to From Separation to Settlement with Jeffrey Hale, a podcast about navigating the legal and emotional journey through family law. Jeffrey is a litigation partner at Kroner Hale Law Firm who has dedicated his career to guiding families through divorce, custody, and other complex legal challenges with compassion and clear, honest advice. I'm Kevin Rosenquist, and of course, as always, I am joined by Jeffrey Hale. Jeffrey, great to see you again.
Kevin, great to be back.
So we're going to talk about post-divorce changes, which I know we touched on to some degree, but we're going to dive a little deeper today, talk about how to modify custody, support, or visitation in Ohio. So let's start here. What is a post-decree modification in family law?
So that can be anything that comes after the final decree of divorce. So the most common, I would say, that we run into are post-decree modifications of basically of parenting time, parenting rights, custody, shared parenting, everything surrounding the children typically are the most common post-decree motions we run into. And then obviously we get into child support, spousal support, but that's probably about the gist of it. The court, typically on property, the court is not very friendly or very kind about any attempts to modify a property distribution. So those are not very common at all, and they're only available in very rare cases. So the most common probably is anything involving the children.
Oh, yeah, okay. And we talked, last episode was all about custody, parenting time and the like. I believe you said, was it 3 years that goes by where they kind of review it again, the child custody and the child support?
No, child support, they review on a 3-year. They do an administrative review every 3 years. Well, it's offered to you. You don't have to do it.
Sure, if everything's working, then you just go about business.
Correct. Now, with parenting time, custody, shared parenting, visitation, those things are always reviewable until the court loses jurisdiction at 18 and graduating from high school. So there's no set time to review that. That can be reviewed at any point in time when a party files a motion and saying that there's been a substantial change in either the child's life or the life of the custodial parent in a custody situation, or just in the child's life and in the party's situation during a shared parenting situation.
Okay, and what counts as change in circumstances?
I mean, it could be anything and it can be nothing at all. So I mean, the court they don't want a lot of back and forth. So it needs to be a substantial change that is a very important change in the child's life or in the lives of the parties. It can't just be, well, typically people will say, oh, well, my ex moved and she's 15 minutes further from me. That's not going to be a substantial change. A 15-minute drive is not going to be that big of a change. Substantial changes can be if a party attempts to relocate out of the state, if a party is remarrying and there's going to be a large blending of the family, and it's going to require a move. If there's a lot of financial trouble and the party's going to lose their home, in some instances, there's a lot of things that can be considered a change. It's just, it really comes down to how detrimental is it, or how detrimental is that change going to be to the child's situation.
What about changes for the kids? Whether, I've known people with kids who are really, really good at hockey and they're constantly on the road, or are really good at, a musical instrument, and they're constantly doing stuff. Are there changes in the child's life that parents might say, okay, we need to figure this out because dad takes kiddo to practice more often, so we have to change our agreement?
So there are instances where children's parenting time, the parenting time involving the children will need to be changed. So as children get older and they get more involved in activities, then the courts understand that sometimes there needs to be a change. There needs to be an adjustment to that parenting schedule. And so that can be something that can get you back into court. And in your scenario, if you have someone who's very good at a sport, they're very dedicated to it, going to it. A lot of times you'll find that parents can work that out, because typically it's both parents wanting to support, that child doing that. So a lot of times you can get that worked out, and where all you're doing is submitting an agreed entry to the court saying we've agreed to make these changes. And if not, then you can go to the court and use, the change in the age, the change in the involvement, to ask the court to reconsider.
So you say go to the court. What is the exact process? Do you need to have your lawyer do something? Do you go to the court and do something? Do you send something in? How does the actual process work?
So technically, once there is an order from the court and the case is essentially over, the court has no jurisdiction until a motion is filed. So the court can enter a decree of divorce, a shared parenting decree, and the case is essentially, I would just call it dormant. Nothing's going to happen with it. And until an attorney, and you don't even need an attorney, you can file a motion yourself. It's depending on what you're filing, it can be very complicated, and there's certain language that needs to be in it that attorneys are used to using and lay people aren't. So, but you don't need the attorney. It's just sometimes it's easier, and people just don't have the time that they want to dedicate to it. So that motion triggers the court's jurisdiction, and that is what allows them to look and reopen the case. And then what takes place after that, is up to the court, up to getting on the court's calendar.
Okay. And, we talked last episode about child support and making changes to that as life changes happen. And you talked about how it's and rightfully so, it's about what's best for the kids. What about spousal support? Can that be modified? And what would trigger that?
So spousal support can be modified. In most instances that I've seen is when you have a spousal support order, if it comes by way of agreement of the parties, then you typically write in that the court will not maintain jurisdiction over spousal support. So that blocks it from ever being modified. And it's typically set for it has a set period of time. So, spouse agrees to pay X amount of dollars for 5 years. The court does not maintain jurisdiction over this section. So that locks it in at $1,000 for 5 years. That's what will be paid, and that's the most they'll ever have to pay. Now, when a court makes a decision, the court can leave jurisdiction open for them to make adjustments and to outright terminate it if it becomes appropriate. So an adjustment would be much like child support if the income goes up or down and there's a large disparity in that income. Terminating it, which can also be written into even an agreed one. Terminating is if an individual receiving spousal support chooses to live in a quote unquote marriage-like relationship, if either spouse dies, or it terminates upon the length of the agreement.
Okay, that makes sense. And we talked a little bit before about you mentioned something about parents moving, and that depending on the distance, that could justify a change. I'd like to unpack that a little bit more. Obviously, you can't just up and leave without telling the other parent and all that. What are the rules as far as one parent wanting to move away, particularly the parent with more parenting time wanting to move away?
So if a parent wants to move, they have to notify the court and notify the other party. It's called a notice of relocation. So you have to file that. And typically if the move is in one of our local courts, if the move is more than 75 miles from your previous address, then you also have to file with that a proposed. If the move is not by agreement of the parties, then they would have to file a proposal for what parenting time is going to look like with this new distance between them.
Yeah, that's significant. That's a lot of distance.
Absolutely. And they have to ask the court, number one, they have to put on notice that they're moving. Then they have to file the proposal asking the court to adopt that proposal. And what's going to happen is that notice and the proposal will get sent to the other party, and that's typically that triggers an objection, and then it gets set for a hearing.
Okay. All right. So, but even, depending on where you live, even a 15-mile move can make a big difference. I used to live in Chicago, and an extra 15 miles, that's going to add a heck of a lot of time to your commute to getting the kids to school or to get the kids back to their parent, to the primary parent. So does the court take that into consideration, or is it just a mileage thing?
They do. So this is where we go into, I think in previous episodes, we had touched on local counsel. So it goes into understanding the local rules. Some courts will set a mileage. Some courts in their local rules say that anytime you're going to be changing household, you need to file that notice of relocation. So that automatically gives notice to the other party. And frankly, it gives notice to child support and to the court. So if they're trying to send you documents, but in my opinion, the important one is getting notice to that other party so that they're aware that this change is coming and they have an opportunity to be heard. Because in the scenario you gave there, and 15 miles going through Chicago traffic's a lot different than 15 miles, going through the suburbs of Cincinnati.
And if you're going to modify a parenting plan, do both parents have to agree to the modification, or are there situations where the court will dictate what that modification is?
So if you have an agreement, then the parents can just simply enter it's referred to as an agreed entry, and they'll put the changes that they've agreed to. And basically that agreed entry will modify that portion of the previous court order. Now, if there's not an agreement, then the court will set it for a hearing. You will present evidence as to why you don't agree with it. They'll present evidence as to why they do agree with it. And then you have a hearing.
So if one parent violates the current order, what does the other parent, what is their course of action? How do they go about letting the court know that it's been violated? And what are the consequences to the parent who did violate the current order?
So the avenue of recourse for violation of a court order is always going to be contempt. Yeah, so the parties will file a contempt or a show cause action and ask the court, basically notifying the court that this individual is violating the order, that they're not following it, and then asking the court to step in and basically punish this individual. If the individual is found in contempt for violating the court order, then there are fines and fees that can be levied. If it's a parenting time issue, then the non-offending parent can get makeup time, and their attorney's fees and court costs can be ordered to be reimbursed. And then ultimately, with a contempt, the court does have the power to put you in jail if you continue to refuse to abide by the court's orders.
Extreme cases, I'd imagine. Hopefully it doesn't happen too often.
Yeah, those are very extreme, because even with a contempt finding, the court has to give the individual the chance to purge that contempt, basically to make that contempt right. And if they do the purge and there's no more trouble, then it goes away. So it's kind of like the contempt never happened.
Mm-hmm.
But you can always come back in and file if they continue down that course.
What are the most common reasons that you see in your practice for modifying an agreement?
Some of the most common that I've run into lately have been when individuals have shared parenting plans. It's believed that the parties are going to continue working together as though the relationship, the marriage had never broken. It's going to be working together to raise the kids, working together to make joint decisions. So a lot of times what I run into, at least it has been very prevalent lately, has been when the parties just can't work together.
Mm-hmm.
One party decides to start making all the decisions, will not communicate with the other party. A major crux of shared parenting is being able to communicate.
Right.
And so you have to basically almost raise the children as though the marriage never broke.
And that's not easy to do. Obviously, you try to do everything you can for your kids, but you're talking about emotions. You're talking about potential. Could be potential anger, resentment, jealousy, what have you. Trying to do that, trying to parent kids with the exact same way as you did when you were together is quite the challenge, I can imagine.
Oh, it is. It is. And one of the things we have to try to help coach clients on is at some point in time, you have to remove the emotion and it has to become a business transaction.
Yeah.
Because that's the only way you're going to effectively parent together is you just treat it like a business transaction. You love your children, you can be emotional for your children, but that other parent is just a business partner to you, and you're trying to raise your children together.
That's a really interesting angle, I think. Like to think of it more like a business transaction, like that you two are in a not, like a partnership that is strictly about these kids and nothing else. If you can get to that point, that's the best outlook you could have.
Yeah, absolutely. You have to look at it as you don't want to use a tone of voice or speak to that person any different than you would speak to a business associate.
Yeah.
And that's how you slowly start to remove the emotion from it.
Yeah, that's a really good tip. I could see that helping if you can get there for sure. All right. Well, thanks for joining us on From Separation to Settlement. If your custody or support order no longer fits your life and you need some help, visit kronerlaw.com to speak with Jeff Hale. Be sure to follow the show so you don't miss out on what's next. We got lots more content coming your way. Jeffrey, so good to see you again. Thanks so much for the time.
Thank you, Kevin. Always a pleasure.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.